Hello, good morning. I am Parameswari, Assistant Professor of Commerce, Jamal Muhammad College, Trichy. Today I am going to discuss about essential elements of a valid contract. First, let us know what is contract and valid contract. Section 2, subsection H of the Indian Contract Act 1872, an agreement enforceable by law is a contract. An agreement is enforceable if it gives rise to legal obligation. What is valid contract? A contract which satisfies all the legal requirements laid down in section 10 of the act is known as a valid contract. A valid contract is an agreement which is binding and enforceable at law. Now, coming to this topic, what are the essential elements of a valid contract? According to section 10 mentions the essentials of a valid contract. All agreements are contracts if they are made by the free consent of parties competent to contract for a lawful consideration and with a lawful object and are not hereby expressly declared to be void. So let us discuss one by one. The first element is proper offer and its proper acceptance. In an agreement, there must be at least two parties, one of them making the offer and the other accepting it. The term of the offer must be definite and the acceptance of the offer must be absolute and unconditional. The person making the offer is known as offerer, proposer, or promiser. The person to whom the offer is made is known as offeree or proposee or promisee. For example, A proposes to sell his car to B for rupees 50,000 and B conveys his acceptance. The agreement comes into existence. In this example, there is no complication. The deal is simple and straight. The next element is intention to create legal relationship. There must be an intention among the parties to create a legal relationship. In case of social or domestic agreements, the usual presumption is that the parties do not intend to create legal relationship. But in commercial or business agreements, the usual presumption is that the parties intend to create legal relationship unless otherwise agreed upon. It means in case any of the unsatisfied party can seek legal solution when agreement terms are not followed. For example, I invited you for a dinner. You accepted the invitation. It is a social agreement. If I fail to serve you, you cannot go to the court of law for enforcing the agreement. Similarly, if you fail to attend the dinner, I cannot go to the court of law for enforcing the agreement. So the next element is free consent. According to section 14, consent is said to be free when it is not caused by coercion, undue influence, fraud, misrepresentation. If the consent of the parties is not free, then no valid contract comes into existence. It is essential to the creation of every contract that there must be free and genuine consent of the parties to the agreement. Consent is free when it is not obtained by fraud, coercion, mistake, and misrepresentation. Example, X threatens to kill Y if he does not sell his house to X. Y agrees to sell his house to X. In this case, Y's consent has been obtained by coercion and therefore it cannot be regarded as free. The next element is capacity to contract. According to section 11, every person is competent to contract who is of the age of majority according to the law to which he is subject and who is of sound mind and is not disqualified from contracting by any law to which he is subject. The parties to an agreement must be competent to a contract, otherwise it cannot be enforced by a court of law. So the person who is entered into a contract must be major, must be of sound mind and must not be declared disqualified from contracting by any law to which he is subjected. Example, X, a minor, borrowed rupees 8,000 from Y and executed mortgage of his property in favor of the lender. This was not a valid contract because X is not competent to contract. Therefore, the mortgage was not valid and the money advanced to minor could not be recovered. The next element is lawful consideration. According to Section 23 of the Indian Contract Act 1872, the consideration is considered lawful unless it is forbidden by law or is fraudulent or involves or implies injury to the person or property of another or is immoral or is opposed to public policy. So, an agreement must be supported by lawful consideration. Consideration means something in return. So, without consideration, there is no execution of valid contract. An agreement can be enforceable by law only when its objective is lawful. If the agreement is having unlawful object, then no legal contract arises between the parties. Example, if A offers to sell his scooter to B for rupees 10,000 and B accepts the offer, then for A rupees 10,000 is the consideration and for B the scooter is the consideration. The next one is lawful object. According to Section 23 of the Indian Contract Act 1872, the object is considered lawful unless it is forbidden by law or is fraudulent or involves or implies injury to the person or property of another or is immoral or is opposed to public policy. So, the object for which the agreement has been entered must not be illegal or immoral or opposed to public policy. That is, the object of the agreement must be lawful and not one of which the law disapproves. See, an agreement on sharing of profit or loss on smuggled goods or illegal trades like selling of banned drugs or unlawful objects. Example, X, Y and Z enter into an agreement for the division among them gains acquired or to be acquired by them by fraud. The agreement is void because its object is unlawful. The next one is agreement not expressly declared void. According to section 24 to 30 of the Indian Contract Act 1872, under provisions agreement in restraint of marriage, agreement in restraints of legal proceedings, agreement in restraint of trade, and agreement by way of wager have been expressly declared void. The agreement must not have been expressly declared void by law in force in the country. Agreement to continue any relationship is not a valid agreement, so the contract is void. For example, X promised to marry none else except Y and in default pay her rupees 1 lakh. X married to Z and Y sued X for the recovery of rupees 1 lakh. It was held that Y was not entitled to recover anything because this agreement was in restraint of marriage and so and as such void. The next element is certainty of meaning. The terms of the agreement must be certain and unambiguous. According to section 29 of the Indian Contract Act 1872, agreements the meaning of which is not certain are capable of being made certain or void. The terms of the contract should be clear. In other words, the contract must not be vague. In this example, we clearly understand what is void and what is valid. Come, let us discuss the example. The first one is X, a dealer in different types of oils, agreed to sell 100 tons of oil to Y. This agreement is void on the ground of uncertainty because it is not clear what kind of oil is intended to be sold. The next example is X, who is a dealer in mustard oil, agreed to sell 100 tons of oil to Y. This agreement is valid because the meaning of the agreement could be easily ascertained from the circumstances of the case. So, in this example, we clearly understand what is void and what is valid. The next element is possibility of performance. The terms of the agreement must be such as are capable of performance. According to section 56, an agreement to do an impossible act is void. An essential of a valid contract is that it must be capable of performance. See, for example, X agrees with Y to discover treasure by magic and Y agrees to pay rupees 1000 to X. This agreement is void because it is an agreement to do an impossible act. So there may be two situations, one in which the act is completely impossible and other situation maybe in which the parties are not aware of that the act is impossible. So the next one is legal formalities. This is the final element of the valid contract. The agreement must comply with the necessary formalities as to writing, registration, stamping, etc. if any required in order to make it enforceable by law. In India, writing is required in cases of sale, mortgages, lease, and gift of immovable property, negotiable instruments, memorandum, and articles of association of a company, etc. Registration is required in case of documents coming within the scope of Section 17 of the Registration Act. All the elements mentioned above must be in order to make a valid contract. If any one of them is absent, the agreement does not become a contract. Example, an oral agreement for sale of immovable property is unenforceable because the law requires that such agreement must be in writing and registered. Thank you.